Hello, everyone. Welcome to Court with Krissy. The cameras don't lie. Obviously, Mr. Challenger is not very happy. So he's got to fire his attorney and file a few oral motions. How do you think that's going to go? But before the main event, just a quick clip when you think you're muted, but you're not. I hope you like it. Court with Krissy is now in session.
A short time here. So to that end, I am going to place you on probation for a period of 1 year.
At the table. I don't know.
As a
$5, I don't know. I ain't got time to be fucking with this shit.
Mr. Wilder, we can hear everything you're saying.
I'm sorry.
Please keep yourself muted until it's your turn for a hearing. Okay, thank you. All right, so we'll get started then on People versus Challenger, file 4156/25. Ms. Mogenberg is here on behalf of the people, Mr. Traeger on behalf of the defendant, and Mr. Challenger. Can you hear me okay?
I can.
Very good. So, Mr. Traeger, what does your client wish to do about the preliminary examination?
Yes, good morning, Your Honor. Mr. Challenger intends to waive this morning's preliminary examination.
I do not intend to waive it. I do not intend to waive the preliminary. I've got no discovery.
Okay.
He won't answer my phone calls.
Hang on, Mr. Challenger. Hang on. We can put you in a breakout room with your attorney to discuss this further.
Please.
Okay. Hang
Please.
on. All right. Welcome back, Mr. Challenger. And so, Mr. Traeger, I guess, what's your client's position?
So I had a conversation with Mr. Challenger on, let me make sure I've got the date correct. That would have been Friday, the 11th of April, where I met him at the Grand Traverse County Jail to discuss the preliminary examination. At that time, we agreed to waive the preliminary examination. Mr. Challenger, since that date, has decided not to waive his preliminary examination, and I understand he is dissatisfied with his current court-appointed attorney. Unfortunately, I don't believe that I can break through to Mr. Challenger about the nature of this preliminary examination or the need to waive it, but I've tried. And so ultimately he wishes to hold the preliminary examination, and I don't believe he wishes me to be his counsel any longer. And this was not my expectation today, sir.
Okay. So, Mr. Challenger, is all that correct?
Yeah, I would put an oral motion in for substitute counsel. He's failed to communicate. I can give you the reason. He's not giving me any discovery yet, and we're already at prelim.
Okay, hang on, Mr. Challenger. So this is the deal. There hasn't been any previous substitution of counsel, has there, Mr. Traeger?
No, Your Honor.
Okay, so Mr. Challenger, I generally am willing to give you one opportunity to switch horses, so to speak. You never know who you're going to get. Mr. Traeger is very capable and experienced. And again, you don't know who you're going to get, but I'll give you this one opportunity to switch counsel if that's what you want to do.
I do.
Okay, so we will appoint new counsel. That means we're going to need to set this for a new probable cause conference and a preliminary examination within the normal time frames. So go ahead, Ms. Martin. And Mr. Traeger, you are now relieved of any further obligations for this case other than providing discovery to the newly appointed attorney.
Yes, Your Honor.
Just a sec, Judge.
1
moment.
Yep.
To the PCC on Monday, May 5.
Okay, so May 5th, PCC.
1, 2, 3, 4, 5, 6, 7. And then Monday, May 12th for the prelim.
Can I put
Okay.
a motion in to change, to lower my bond?
My understanding is you're incarcerated on another case through
Which ends on May 4th.
May 4th. Okay. Well, let's see. I'm looking at the praxis report. It says you've failed to appear 3 separate occasions in the past. So that's a big concern. And let's see. There's also the fact that this is a home invasion fourth, a life offense. Let me see where the bond is currently. So 50,000 cash or surety sounds about right for the nature of the offense and the failure to appear in the past. Ms. Mogenberg, what's your position? And we'll hear more from Mr. Challenger in a minute.
Your Honor, given the defendant's extensive criminal record as well as his prior 3 failed to appears and the severity of the offense, we would ask the court to maintain bond where it is at this point.
What else would you like me to know, Mr. Challenger?
I guess you won't reduce the bond, so that's okay.
Well, I'm always willing to hear an argument, but it does
okay.
appear the bond. Go ahead.
I missed the one time 2 years ago, and I went through all that stuff with that, and then this time I didn't miss this time. I mean, I've been out on bond, on a PR bond, and I showed up for these hearings, every one of them. I'm not going anywhere. I was born here in Traverse City at Munson. My family is here. I'm not going anywhere. You know.
Okay. My biggest concern. Yeah.
Well, and I think that when we look at the film footage, we're going to see that it's not what it's put up to be. So, I mean, the cameras don't lie. So, whatever. There was no felony committed here. There was not.
Okay.
There wasn't.
From the little bit okay. All right, Mr. Challenger, stop.
Okay.
So my concern isn't so much with the failing to appear, although that's important, and the fact you're charged with a life offense is important as far as whether you're going to show up or not. But I also see a history of assaultive offenses, including domestic violence, 3rd offense in 2019. There are drug offenses. There's a DV in 2012 and 2015, and an aggravated assault in 2017. And that's just in the last 10 years anyhow. So I've got concerns about the threat to the public. And so I'm going to keep the bond right where it's at. We'll see you back here for your probable cause conference on the 5th. We're all set. You can let the jail staff know we're all set for this morning. Thank you.
Thank you, Your Honor.
Thank you, Ms. Mogenberg.